Judgment Day. Make una come here, then they Supreme Court, then they sit down. Now wetin happen be that technicalities. Now these technicalities, sha. Hey, Alhaji Atiku Abubakar, the rep and put all in Chicago State University finding for inside dustbin. My people, make some money to sue. She need to sue for character assassin. Make her not just talk and finish. Meanwhile, we need to look into law school for Nigeria, whether we need law school or we don't need them. Because what with the sister, my people, let me share and leave your update. Hey,
in determining this motion has to take into consideration the peculiarity of the instant appeal, which is an appeal against the judgment of the Court of Appeal, sitting as the Presidential Election Petition Court, based on the provisions of the Constitution of the Federal Republic of Nigeria and the Electoral Act 2022. I have carefully perused page 1 of volume 1 of the Record of Appeal, and it is very clear that the petition giving birth to this appeal, and particularly this application, was filed on the 21st of March 2023, which was the last day of the 21 days prescribed in Section 285, Sub 5 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, for filing of election petitions after announcement of result of election. By subparagraph 6 thereof, an election tribunal shall deliver its judgment in writing within 180 days from the date of filing the petition, and where there is an appeal, it shall be determined within 60 days from the date of delivery of judgment of the tribunal or court of appeal. As pointed out by learned senior counsel for the respondents, the 180 days prescribed for the hearing of the petition by the Court of Appeal lapsed on the 17th of September 2023. In other words, the court below lost its jurisdiction to determine any matter in relation to the petition. This application before us relates to fresh evidence obtained after the judgment of the lower court and after the 21 days for filing election petition and after the expiration of the 180 days of the filing of the petition. What are the legal and or constitutional implications of the above scenario in relation to Exhibits A and D sought to be received into these proceedings? Several of the decisions of this court have taken care of the above scenario. One of the most recent cases decided by this court is the case of Towo, Womo, and Ajayi, the citation supplied there, wherein this court stated as follows, and I'll quote, "In the circumstance of this case, this court cannot activate Section 22 of the Supreme Court Act 2004, since the 180 days provided by the Constitution to determine the appellant's claim at the trial court has lapsed since 1st January 2023. The originating summons was filed on the 5th of July 2022 and expired on 1st January 2023 at the Federal High Court. This appeal was taken on 2nd January 2023, and there is no opportunity for the contentious issues of fact in the controversy in this appeal to be sent back to the trial court. The issue of the merit of the allegations of false information was not tried by the two lower courts and cannot be tried by this court pursuant to Section 22 of the Supreme Court Act. This court cannot do what the trial court is no longer constitutionally permitted to do by virtue of Section 285 of the Constitution of the Federal Republic of Nigeria, the Groundnum. See OK Mimiku, see APC and Marafa, all citations supplied. As stated by the appellant applicants in their application, the reliefs they seek is an order of this court granting them leave to produce, and for this court to receive fresh or additional evidence by way of deposition on oath. Clearly, the application runs foul of paragraphs 14 sub 2 and 16.1 of the first schedule to the Electoral Act, which inter alia outlaws any amendment of substance, as in this case, or introduction or addition of substance to the statement of facts relied on to support the ground of the petition after the expiration of 21 days prescribed in Section 132, sub 7 of the Electoral Act for the presentation of an election petition. There is no doubt that the deposition is one of substance, and that is in fact why the appellants are seeking to introduce it into this appeal. For the avoidance of doubt, I shall reproduce Section 14.2, paragraph 2A of the first schedule to the Electoral Act 2022 as follows. After the expiration of the time limited by A, Section 132(7) of this Act for presenting the election petition, no amendment shall be made. No amendment shall be made. 1. Introducing any of the requirements of paragraph 4.1 not contained in the original election petition filed. Or 2. Effecting a substantial alteration of the ground for or the prayer in the election petition. Or 3. Except anything which may be done under subparagraph 2A2, effecting a substantial alteration of or addition to the statement of facts relied on to support the ground for or sustain the prayer in the election petition, end of quote. Nothing can be clearer than the above provision, which clearly states that a petitioner shall not be permitted to amend his petition after 21 days allowed by Section 132 sub 7 of the Electoral Act. The applicants herein have not even applied to this court to amend their petition in order to reflect the fact of forgery, and Exhibit C and D sought to be admitted into the proceedings. Facts and documents which were not pleaded in the petition have no place in deciding the dispute between the parties. I still wonder how the appellants intend to use those documents in this appeal. Let me consider an unusual submission of the learned senior counsel for the appellants applicants. It is in respect of Section 285 sub 6 of the Constitution, which states, an election tribunal shall deliver its judgment in writing within 180 days from the date of filing the petition. But on page 3, paragraph 2.5 of the appellant's reply on points of law, he argued as follows, quote, interestingly, and contrary to the avowed position of the respondents, we make bold to submit that there is no such constitutional limit of 180 days on the lower court to hear and determine a presidential election petition, such that can rob this court to exercise its jurisdiction in any manner whatsoever. While establishing the election tribunals to deal with election matters from houses of assembly, National Assembly and governorship elections, the Constitution gave jurisdiction to entertain disputes from presidential elections only to the Court of Appeal. Thereafter, the Constitution was intentional and deliberate in setting the 180 days limit only for elections tribunals and not for the Court of Appeal, end of quote. It is shocking to have the above argument in print. It could have passed for a friendly joke, but not for a serious matter like this in the apex court. It is even an unnecessary joke over a constitutional provision. After election petitions had suffered under the previous provisions, which allowed election petitions to be heard even until the respondent has completed his tenure, and the National Assembly dealt with the mischief by limiting the time which election petitions shall be determined, it is unfair to suggest that we go back to those dark days. My lords, there is nothing in section 285(6) of the Constitution to suggest that the Court of Appeal can hear presidential election petition without time limitation. The lower court is bound by the provision of section 285 sub 6 of the said Constitution when sitting to hear election petition, just as other election tribunals, as was rightly submitted by the learned senior counsel for the third respondent, Chief Akin Olujimi SAN, for which I wholly agree. The appellants knew they had to prove the allegation of non-qualification raised at paragraph 16D and 146 of their petition against the second respondent within the 180 days adjudication window provided in section 182 sub 8 of the Electoral Act 2022 for determination of petition by the lower court, which expired since 17 September 2023. The 180 days having expired, the lower court therefore no longer had jurisdiction to allow the deposition sought to be introduced into the trial of this petition. This is the law which at this stage is elementary. Consequently, since the lower court no longer has jurisdiction to entertain any such application, it follows ipso jure that this Supreme Court, also has no jurisdiction to allow the deposition to be used in this appeal. It is settled law that where the time for doing a thing is limited by the Constitution or statute, the court cannot extend the time. That was the decision of this court in Brigadier General Mohammed Buba Mawar and Admiral Mortala Nyako, where Onogan JSC, as it then was, held as follows. Quote, it is settled law that the time fixed by the Constitution for the doing of anything cannot be extended. It is immutable. It is fixed like the Rock of Gibraltar. It cannot be extended, elongated, expanded, or stretched beyond what it states. See also Abubakar and Nasamu, all citations supplied. It has to be noted, as I stated earlier in this ruling, and for which there are several judicial decisions in this country, that the 180 days imposed on election tribunals and courts hearing election petitions is immutable and cannot be extended. The applicants have not even applied for extension of time to bring in the said depositions or extension of time to amend their petition. Let me say it clearly that 21 days provided for the filing of petitions having long expired, even if the appellants had applied for extension of time to amend their petition in order to bring in the depositions, it would not have been granted based on the provisions of the Constitution and the Electoral Act.